Hi, my name is Joe Bartolomeo. I'm an Oregon workers' compensation lawyer. I have offices in Hillsboro, Oregon, and Astoria, Oregon. And in today's video, I'm going to talk about two different kinds of claims that you can make with a workers' comp claim. This is the initial claim that you make. And I'm also going to get into detail about what it is you have to show to prove the claim. Now, lawyers call this the burden of proof, the standard of proof, but I'm just going to kind of lay out how much you have to prove and what you have to prove when you make these kinds of claims. Now, I have other videos where I talk about claims that are made after a claim's been accepted, which is something that can happen and maybe should happen in some cases. Then I have a video that talks about claims that can be made after your claim is actually closed, where you're reopening the claim to get more medical care. But in this video, we're at the very beginning of the claim. So let's talk about that. We'll start out with what's called the injury claim. What I'm going to do is start out by talking about injury claims. Now, there are two kinds of claims that you make at the initial claim filing, right after you've been injured or you've required medical care. They're called the injury claim and the occupational disease claim. But we're going to start with the injury claim. So an injury claim is a claim for medical care that occurs because of an incident that occurred at work that is discrete in time. So a classic example of an injury claim is a claim of a fall injury. You fall and you injure yourself, or a lifting injury where you lift a heavy item at work and you have sudden lower back pain, and it happened in a discrete period of time. That's an injury claim. The reason an injury claim versus the occupational disease claim, which I'll get to in a minute, the reason that's a big deal is because there are different standards or burdens in proving these different kinds of claims. An injury claim requires that you show that it's more likely than not that the event at work, lifting, falling, whatever it may be, is a material cause of your need for medical care. So let's break that down a little bit. A material cause means a significant cause. It doesn't have to be the only cause. It doesn't have to be the dominant cause. It only needs to be a significant factor or a significant cause in your need for medical care. And that can be a big deal because doctors, who are essentially trained as scientists, like to be precise and exact in their opinion giving when they are asked to give an opinion. And what we're dealing with here is you proving that it's more likely than not, more probable than not, that the lifting incident at work is a significant factor, maybe not the only factor, but a significant factor in causing your need for medical care. So it's not like a doctor making a diagnosis. It's more likely than not, the injury event at work is sending you to the doctor, or it's keeping you from being able to work. So that's a pretty, I'm not going to say it's an easy thing to prove, but it's less rigorous, it's less exact than other kinds of claims in the workers' compensation system. And it could make or break a case. So it's a big deal in that respect. The other thing about an injury claim, especially when we're talking about the initial filing of a claim, is you do not need to prove a specific diagnosis when you're making the initial injury claim. And so if you go to a hearing on a workers' comp claim and you put this all in front of a judge, you only need to prove, again, that more likely than not, your work activity was a significant factor in causing you to have to see a doctor or causing you to be disabled from work. And there's specific case law that says you don't need to give a diagnosis. You don't need to say, oh yeah, this was a meniscal tear, or this was a anterior cruciate ligament tear of the right knee. You just need to be able to show that something happened, you needed to go into the doctor. Now, that being said, one of the other things you have to prove is that there's some objective evidence in the medical record that shows some need for medical care. So objective means that the doctor observed it, whatever it may be. The doctor was able to observe some sign of injury without asking you. So when a doctor examines a patient, the first part of a medical exam is to take a history. That is you telling the doctor what happened. The next part of that is the doctor doing an exam, and they might do certain testing to kind of zero in on what's going on. For example, we're talking about a knee injury. They might check the stability of your knee, the range of motion of your knee, whether there's swelling, that kind of stuff. If they get a positive test result, or they can see swelling, or they can see that there's limited range of motion, those are objective signs. It has to be something that's observable or repeatable. And there's case law that talks about, what kind of things are objective. So there's got to be some objective evidence. So that's an injury claim. So it's more likely than not the injury event, what you were doing at work, was a significant factor in causing you to either see a doctor or be taken off work, supported by some objective medical evidence. That's the injury claim. So let's move on to the occupational disease claim. So we covered the injury claim, and then this part of the video talks about what's called an occupational disease claim. An occupational disease claim is something that you are exposed to at work that caused a specific medical problem. So I think a better way of explaining this is to talk about examples. So the most common examples, let me get my mic wire here figured out. Okay. The most common examples of an occupational disease claim, in my experience anyway, is the hearing loss claim. So I don't see this as much as I used to, because a lot of these workers have since retired, and hearing protection has gotten better, not completely better, but it's gotten better in the lumber mill arena or environment. But let's say that you work at a plywood mill and you've done it for 20 or 30 years, and it was before we had decent hearing protection. Well, after so many years of doing that kind of work without adequate hearing protection, you're probably going to have some problems with your hearing loss. So that's a classic example of an occupational disease claim, because it's something that you are exposed to at work, and it occurred over a period of time, a long period of time. And little by little, day after day, month after month, year after year, the nerves in your inner ear are damaged and you suffer hearing loss. That's an occupational disease claim. So the big difference between that and the injury claim is we're talking about a long period of time. The other big difference, or another big difference, is that you have to show a stronger relationship between your hearing loss and what you're exposed to at work. So in an occupational disease claim, you have to show that it's more likely than not, through a medical opinion, that the work or the noise that you were exposed to at work is the major cause of your hearing loss. So what we're talking about there is, if we have a scale of justice and we're weighing the relative cause, if this is the work activity, the contribution of the noise at work has to be more of the cause of your hearing loss than all other causes combined. So in this side, or on this side of this scale, we could pile on age, we could pile on riding motorcycles, we can pile on going to rock concerts, or playing loud music, or cutting your own wood, or whatever that may be. It could be childhood diseases that damage your hearing. But the medical opinions have to weigh the relative causes of the hearing loss, work, other factors. And to make your claim, you have to have a medical opinion that says, look, I've considered everything, and here's the non-work stuff, and here's the noise at work, and the noise at work is more of a cause than anything else combined, and that makes the claim. So that's the proof of a hearing loss claim. The other thing about hearing loss claims or occupational claims in general is that they have to point to a specific diagnosis. Another good way of showing that is with carpal tunnel syndrome, repetitive use. You see that in seafood cannery workers. You see that with pulling green chain at a lumber mill, things like that. And you're going to be in the same boat. You have to show that the repetitive stress at the workplace, when compared to all other causes combined, is the main or dominant cause of your carpal tunnel syndrome, and that's done with a medical opinion. So that's the occupational disease claim. They are more challenging because the burden of proof is more enhanced, and you have to make a stronger showing of that nexus or relationship between the work activity and the diagnosis, and you have to prove a specific diagnosis as opposed to an injury claim. So that's the other kind of claim. Now, sometimes in the workers' comp arena, in a denied claim, you may walk into a hearing and there may be an issue about whether should this be evaluated as an occupational disease claim, or should this be evaluated as an injury claim. And so a lot of times that's an issue, and the burden of proof that I'm talking about, that I covered, that's why, because you may be able to prove an injury claim, but you might not have enough to prove an occupational disease claim. So it becomes a big deal. A case that I always remember is a guy who was unloading a truck over a 2-week period, and the court said, look, that's discrete enough to be an occupational disease claim because there's a beginning, and an end. And that makes the case for an occupational disease. But if this same person was unloading trucks for 3-4 months or a year, and they had lower back pain or carpal tunnel or whatever, now we're getting more toward maybe an occupational disease claim. So that's a case-specific thing. Now, if you have questions about a workers' comp claim, I have a guide that you can look at. I'll put a link down below my YouTube video, and you can download that. It doesn't cost you anything. We don't share information or anything like that. I have You Just Filed Your Workers' Comp Claim guide. It's a bit shorter and more focused. The website has a lot of articles that you can check out. If you need to contact us, you can do it. You can do it through the web contact page, or you can just give us a call. And if we can't help you, we'll put you in touch with somebody who can. Now, I haven't said this, I think, in my other workers' comp videos, but the thing about workers' comp that keeps it interesting but also can drive me crazy is that the law on workers' comp is changing all the time. The Workers' Comp Board is always putting out new decisions. The Court of Appeals is periodically issuing new decisions. And so take that with a grain of salt when you're watching this video. The other thing you should keep in mind is if you have had a denial or a claim closure or something like that, make sure that you check out the time limits in requesting a review or appealing that decision. They're strict. It's hard to get over those time limits. So I always like to put that out there for you just to make sure you understand that. Thank you so much for watching. I hope this was a helpful video for you. Take care.